So for more analysis, then I'm joined by Ulrich Roux to help me unpack this particular situation. Ulrich, thank you for your time. So just, dispassionately, tell us what the law is in as far as this question of medical parole is concerned. The section that Correctional Services is quoting is Section 75(7)(a) of the Correctional Services Act 111 of 1998, which gives discretion to the National Commissioner for placing people on parole, people who are in incarceration for a period of 24 months or less. Are they within the lines, at least in as far as the law is concerned?
Good afternoon, Thulasizwe. Thank you for having me. Yes, certainly. A lot of people have also reached out to me and said that this is just a case of history repeating itself. But as you correctly pointed out now, our Correctional Services Act, as well as the Parole Act, does make provision for a person to be placed on medical parole should he or she be able to prove to the parole board that he is a person who qualifies in terms of the Act to be placed on medical parole. And it certainly seems as if this has been the case in this instance, that a medical report furnished by Jacob Zuma's lawyers confirms that he is suffering from a severe medical condition, that he has undergone a serious operation recently, and that he will need extensive medical treatment going forward, and that keeping a person like that incarcerated is an infringement on his constitutional right to said medical treatment. So, unfortunately, we have not had sight of this medical report, and I do think that, there will be applications launched by the opposition political parties or other interested parties for that medical report to be made available. But our Act does make provision for a person to be placed under medical parole, and it seems as if Jacob Zuma has convinced the parole board that he is a person to be placed on parole given his current medical circumstances.
So in terms of this section, Ulrich, the decision lies squarely with the Commissioner of Correctional Services, who is himself a creature of the Constitution in terms of the security services, but also purporting to act in terms of statute. What answers and what questions arise in terms of the rationality, right? If we park the issue of Jacob Zuma going home and let Jacob Zuma go home, what answers and what test does Arthur Fraser need to satisfy for his decision to stand and be valid?
Yes, I remember that, as you correctly point out, the Commissioner does make the final decision, but he is advised by the parole board, and that is a board that is put together by the Department of Correctional Services, and they evaluate all available information and all available evidence in order to make a determination as to whether a person qualifies for medical parole or not. So they would have looked at the medical reports furnished. I see that they have confirmed that it was not only one report, that it was more than one report that was furnished, and that that qualifies Jacob Zuma as a person who is released on medical parole. I think that one thing that we must remember is that he's not suddenly now a free man who can just roam the streets and attend to social gatherings and, for instance, go to restaurants, etc., etc. He is a person who will now be placed in a medical facility, and that facility will have to treat him where he is currently, as reports have confirmed. And subsequent to him receiving treatment, he will then be, if his situation confirms that, be placed at home or serve out the rest of his sentence at home in order for him to continue to receive that medical treatment. His application for being released on medical parole, which has now been successful, would be accompanied by a number of conditions that he would adhere to. Conditions can, for instance, be that he's only allowed to leave his residence in order to attend a religious function or to receive medical treatment. he's only to receive visitation from family members at certain times and on certain days, etc., etc. We have unfortunately not seen what those conditions are. But yes, there is also the possibility of an application being made to the Parole Review Board should further evidence come to light. So, for instance, if there is an evaluation that is conducted on Jacob Zuma's health, and that evaluation confirms that he, in fact, does not suffer from the conditions which he claims, and that he is a person who can be detained for the remainder of his sentence, then the Parole Review Board can consider such evidence in deciding whether his parole should be revoked or not. Similarly, if he does break any of the conditions or that have been imposed upon him, or he does not adhere to those conditions, his parole can also be revoked by the Parole Board should that be brought to their attention. So unfortunately, at this stage, we are a bit in the dark. We are not even certain as to what medical condition he does suffer from. But I do think that, transparency must be applied here, and that would, take the relevant court and take the relevant people into their confidence and confirm what his medical condition is, what the extent is of the treatment that he should be receiving, and, what his medical parole conditions are.
You're right. So just lastly then, Ulrich, I'm just thinking, thank you for that detailed explanation of some of the conditions that usually attach to someone who's released in the manner that he is being released. I'm just thinking, though, that could the fact that, he's not fit to remain within the custody of correctional services, custody in the traditional sense, in the sense of being incarcerated in a prison while remaining subject to correctional supervision, community supervision. Could the fact that a medical condition and a report played a role in that decision link with his fitness or otherwise to stand trial, which is a separate matter pending before the High Court in Pietermaritzburg, where also the question of his health has come up and questions of the need to have a medical report presented before the presiding judge are also at play in that. Could this become something that comes up and has an influence in how that case evolves?
Yes, certainly things have become quite complicated, have they not? On his last appearance in the Pietermaritzburg High Court, Judge Kuhn made an order that the matter be postponed in order for the court to be furnished with a medical report from Jacob Zuma's doctors. But the court furthermore also made an order that he must avail himself to be evaluated by state-appointed doctors as well. In other words, the court wanted two medical reports in order to make an informed decision as to whether he is a person who is able to stand a criminal trial pending his or given his medical condition, or whether his medical condition precludes him from doing so. So the decision by the Parole Board and by the Commissioner does not affect that court order from Judge Kuhn. That court order still stands. And, of course, we heard last week the Jacob Zuma Foundation coming forward and saying that he will not be making himself available for an assessment by a doctor appointed by the state. And if that is his attitude and if he refuses to be assessed, then he could very well be faced with another contempt of court application by the state, because the court order by Judge Kuhn is 100% clear that he must make himself available for such an assessment. And more than that, his legal representative agreed to that order being made. So he in fact agreed through his legal representative that he would make himself available for an assessment by a state-appointed doctor. So, one scenario that we could be faced with here is that if he is forced to be evaluated by a state-appointed doctor and that report is not consistent with the report from Jacob Zuma's own private doctor, then that could very well be evidence that could be presented to a parole review board in order for the decision to release him on medical parole to be reviewed and either confirmed or set aside. So certainly there could be some interesting developments in the near future pertaining to Jacob Zuma. As has always been the case with him, things become much more complicated than what they should be. Just the fact that he agreed through his legal representative that he could be assessed by a medical doctor appointed by the state, and now refuses to do so, certainly leaves a bad taste in the mouth. And one could advise him to just stop the delaying tactics and carry on with the process, and we'll have to wait and see whether he forces the court's hand to hold him in contempt if he does not adhere to that condition.
Yeah, thank you for that. That's a legal expert there, Ulrich Roux, joining us and really just taking us through some of the processes and some of the conditions for medical parole. And right at the end, they're talking about the implications for the matter pending before Judge Piet Koen in the High Court in Pietermaritzburg. It really will be interesting to hear what the attitude of the NPA is around this investigation, this medical officer that is meant to have a look at Jacob Zuma's health that we are told is not being allowed to do that. You're watching